Okay, good morning, everyone. If you are here for today's webinar on workplace violence and sexual harassment for brewers, distillers, and winemakers, you are in the right place. The voice you're hearing right now, my name is Dan Deacon, and I'm an associate at Conn Carey. I'm joined today by my colleague, Erin Gelb, and we're going to be talking about some OSHA and employment law issues related to workplace violence and sexual harassment today. This is really a timely topic given the rise over the past couple of years of the Me Too movement and what seems to be the increase in violence going on throughout our society today. As you all are businesses that deal with the public, as well as your employees, of course, this is something that you should be in tune to, paying attention to, and it's very important that you take workplace violence and sexual harassment serious, given the potential liabilities and repercussions for you as a business owner. So moving on, we're just going to get into introductions, some quick introductions, and I'll turn it over to Aaron really quick to introduce himself.
Thanks, Dan, and nice to have an opportunity to speak with everyone, particularly in one of my very personally favorite industry segments. I know that I certainly have been doing my part to keep you all afloat during this pandemic, fully stocking my home bar with beer, wine, and particularly bourbon. So my name is Aaron Gelb. I'm a partner in the firm's Chicago office. I focus my practice primarily on occupational safety and health matters, handling largely in Illinois, the Midwest, Wisconsin, through Michigan, Ohio, Indiana, down into Missouri, but handle matters throughout the country, managing inspections, responding to catastrophes, fatalities, amputations, and events like that. I also have, for the past 25 years, have been focusing on management side employment litigation, defending employers in all manner of EEO claims in federal and state court, trying cases to verdict in a number of federal courts across the country, whether in sex discrimination, race, harassment, family medical leave, and even USERRA, which is the military status law. So happy to be here and have an opportunity to speak with everyone. And Dan, I'll turn it back to you for a minute.
Thanks, Aaron. Like I said, my name is Dan Deacon. I'm an associate in the DC office at Conn Carey. And like Aaron, I work in both the OSHA and the employment groups, representing employers during inspections and investigations conducted by federal and state OSHA. And I deal with pretty much every employment law that you can think of, and I advise and counsel employers on all aspects of the employer-employee relationship, including discrimination, wage and hour disputes, and several others. I also assist employers in reviewing and revising employee handbooks and drafting workplace policies and procedures, some of which we're going to be talking today related to workplace violence and sexual harassment. So we're going to go over really quick just the agenda for today's program, and then we'll dive right in. So first, we're going to go over what is workplace violence, how can you identify it, and how do you really define what that is in your workplace and how to look out for it. Next, we're going to go over some of the OSHA implications of workplace violence and how that's regulated by OSHA and other state OSHA programs. Next, we're going to go into the employment ramifications of workplace violence and harassment. And finally, we're going to tie it up with sexual harassment as workplace violence. And throughout the program, we'll be giving you tips of how to best address these issues in your workplace. So Aaron, I'll turn it over to you to start with the OSHA piece.
Thanks, Dan. And let's start by talking or the definition of workplace violence. What is it? I think most people, when they hear the term, their mind immediately goes to the worst of the worst type events, the ones that grab national or local media attention. Here in Illinois, we everywhere in the country. I mean, obviously, it happens everywhere, and all workplaces, any workplace, whether it's open or closed to the public, And we'll talk kind of about the differences about those in a second. But every workplace, if you have employees, you have the potential for workplace violence. So here in Illinois, we've had a number of high-profile incidents. One a year or so ago is often the case, triggered by a termination of an employee who then went out to his car, came back with a gun, and killed a number of people in the workplace. Those are the ones that typically garner attention, the media attention, the wall-to-wall coverage. But in reality, it's obviously a much broader concern. It can include things obviously like murder, or active shooter, but it can cover something as basic as a threat. One employee says to another employee, "I'm going to get you. Wait till after the shift," or "I've got friends. My cousin is a tough guy. He's going to come beat you up." Or "I've got, wait till you see." It can be a veiled threat, not even a direct threat. Just like, "You're going to get yours." It can be bullying. And as Dan alluded to, and we'll talk about a little bit later, certain types of sexual harassment can cross over into and become violence if they involve assaults, frequent harassment, intimidation, things like that. So it's a much broader topic, and it encompasses all manner of conduct and behavior. And so one of the things, obviously, when we talk about having a policy or a procedure in your employee manual, your handbook, it should you want to make clear, obviously, that it addresses and encompasses all these types of conducts or behaviors, so employees understand what is covered, what is prohibited, what is, so they can guide their own behavior, but also so they know if they're experiencing certain things, that there is a remedy, that it is something that the company or the organization is concerned about. So moving on to the next slide, what are the sources of workplace violence, right? I mean, I think for many, we all recognize that it can be one employee harming or threatening to harm another. Sometimes in many cases, it can be, as the example that I shared a minute ago, a terminated employee. Obviously, when there is a termination, and we're all obviously going through some very significant, or many employers are dealing with significant issues relating to the pandemic, layoffs, restructuring, particularly if you have a pub or food service through your establishment. If you're in an area where there's limited 25% occupancy, 50% occupancy, you're finding it difficult to continue operating. Maybe people's hours are getting cut or they're being terminated. Typically, we find that that's a little bit less of a concern. But it's when people are terminated, in many cases, for discipline, for some sort of incident or conduct, performance reasons, that whatever is going on with them, that triggers this reaction, in particular if they have one person in particular that they blame or focus on. But it can even happen with a rejected job applicant. Not to reach too far back into history, but President Garfield was assassinated by someone who was a deranged patronage seeker, was not given a position that he sought, and he assassinated the president. So it doesn't have to be someone who even has worked for you. And then, of course, just the routine disagreements amongst employees that can escalate, and whether it's over a performance or work-related issue, or perhaps people that have dated in the workplace, what have you. Then there are known third parties, and this in many cases can be one of the greatest hazards. Spouses, particularly domestic partners. Someone may have a stalker. It can also, of course, be clients or patrons, people that are regularly in the workplace. You might have an issue where the copy repair person, or someone who's delivering raw materials or products to your facility, develops an obsession with one of your employees. One of the cases that I think it's helpful to talk about, real world examples. I was hired by a hospital system here in Chicago after they received a citation for having an inadequate workplace violence program when a female employee was killed by her. He wasn't yet her ex-husband. They were separated, living apart, and he found out that he was disinvited from her family's Thanksgiving celebration, and that sent him over the edge. And he followed her to the parking lot one day and shot her to death in the parking lot. The reason that the hospital in that case was cited by OSHA for having an inadequate workplace violence program was that they looked at the program generally and found it to be deficient because it didn't talk about the recognized hazards in a hospital, which would be from the patients in certain departments, such as the psych ward and the emergency department. We were able to get the fine reduced to zero because this was not a recognized hazard. No one knew that her husband was violent. She never complained about him. But had she done so, had she put the company on notice, then it would have been a very much different story, because then they would have been aware of this potential hazard. And then the last category of where this threat or actual violence may come from are those with criminal intent, such as someone who's seeking to rob, get your cash till. Perhaps there's just general criminal activity in the area in which you operate. And then the one that's probably hardest to plan for is just someone who has an irrational connection with your company. Someone who maybe has an issue with the liquor industry or something like that. Those again can be the hardest to plan for. So then moving on to some statistics, just to kind of, I think, orient you all to what you're dealing with here. Really, some of these are, I think, pretty staggering. So if you 18%, so nearly 20% of all violent crimes happen in the workplace. And obviously right now we're dealing with, a lot of people are working remotely, so maybe that statistic will change. But at the same time, people are more stressed than ever. There are issues that we're all facing, from the health and safety aspect of the pandemic to the larger issues in our society that are increasing. I think, as Dan said, we're seeing violence on the news all the time. We're seeing protests. So the likelihood that these types of issues kind of boil up and come into the workplace is as high as ever. 21% of the crimes that are committed or occur in the workplace involve weapons. Obviously, most of those are guns, as well as knives. Of the 4,836 fatalities in the last count that occurred in the workplace, about 10% were homicides. And so that's a pretty significant number if you think about it. 1 of every 10 people who die in the workplace die in a violent incident. And I think this gets to that category, the next statistic that this relates back to what I talked about, this kind of the known hazards or the known offenders. In many cases can be a stalker or an ex-spouse. So the number 2 cause of workplace fatalities among women is workplace violence. And I think that's a fact that when we talk about policies, we talk about training and making sure that your employees understand the remedies or the tools that are available to them when you adopt and roll out this policy or this procedure, that your employees understand that if they have a domestic incident, if they have someone who's stalking them, that they should let you know. So your managers and others can be on notice and aware of that person. They should, you want your employees to know that, share a photograph, tell us what's going on so we can help you. I mean, that was what didn't happen in my hospital case. So the hospital didn't know that this was an issue. Now, I didn't mention that the man who killed her was also a hospital employee, which complicated things further. But had he not been, certainly the hospital could have, put his photograph up, could have briefed security to be aware of and on the lookout for this person. Overall, more than 2 million employees report being victims of workplace violence. And again, that gets back to all the types. So it's not just people that are actually assaulted or injured. shot or stab, but people who that includes bullying, intimidation, threats, things like that. And at the same time, and I think one of the reasons why we do programs like this is to really get the word out and try to encourage our friends and our clients to adopt a workplace violence prevention program. So if you look at the last couple lines, only 30% of private employers have a program, and of that, many are probably in fields like hospitals and retail, where the hazard is greatest. But because this affects all types of workplaces, regardless of industry, we strongly recommend that everyone have a program, and then train their employees on the program. So then moving on to the next slide, just a couple of examples, and I think that a number of these are important or raise some important issues, and just kind of jumping around. The one that I was referring to here in my backyard, in essence, in Aurora, Illinois, last year in February of 2019, 5 people were killed, including, obviously every loss of life is tragic, but I believe that the HR intern who was killed, it was maybe his first or second day on the job. The plant manager was killed, the HR manager was killed, and just obviously a horrible situation. The Twin Peaks, and certainly for those of you listening today, I think is an interesting one. So that was a restaurant. Some or all you may be familiar with the chain. I won't get into their business model. You can Google it if you want, but you may need your privacy settings changed given the type of restaurant that it is. But apparently this biker gang meeting regularly took place at this restaurant in Waco, Texas, and this was not like the first time that this group of bikers had gathered at the restaurant. And not surprisingly, after this melee broke out, 9 people were killed, that OSHA investigated both the franchisee that was operating the restaurant as well as the corporate franchisor, the Twin Peaks company. And I think one of the issues that people don't always consider with workplace violence and OSHA's role in kind of addressing it, in addition to the potential for a safety and compliance inspection, as some of you may be aware, that the OSHA Act also has a anti-retaliation provisions, Section 11C of the OSHA Act. And it essentially provides that employees who engage in protected activity that deals with health and safety can't be retaliated against. So I obviously we don't represent Twin Peaks. I don't know what may have happened before that incident, but let's say a server had come forward and complained to his or her manager, probably her manager, given the type of business that Twin Peaks operates, and said, this gang comes in here every week or every month, and I've noticed some fights, and I don't feel safe working that shift. And the manager says, if you don't work that shift, that's a lot of business that they bring when they have this meeting. You're going to be taken off the schedule. You're going to be terminated. That is a protected activity. I responded on behalf of a client late last year with respect to a 11C retaliation claim involving workplace violence, where 2 employees got into an argument. One employee was deemed to be the aggressor. He was terminated, and in response, he filed a retaliation claim alleging that no, he had complained about the other employee first, and that's why management fired him, not because he was the aggressor in the incident that occurred, but because he had engaged in a protected activity, raising a complaint about his coworker's conduct. So in many cases, when you're evaluating a potential termination, your HR person or your lawyer may say, well, what is the age of the person? What is the race of the person? What's the sex, et cetera? Kind of going through the EEO checklist. And they may not think to ask, has this person engaged, or they may say, is this person engaged in protected activity like complaining about sexual harassment, but maybe someone doesn't think to ask, did they also complain or was workplace violence ever brought up as a concern. So if someone is complaining, saying they don't feel safe in the workplace for whatever reason, just understand that that is something that OSHA could look at as, or would consider to be a protected activity. So moving on then to the next slide, just to kind of orient you, I talked about in the Twin Peaks case that OSHA did conduct an inspection there, but it's important to recognize or understand that there is no OSHA regulation dealing with workplace violence. For those of you that either have participated in other webinars that we've done or have a general working knowledge of OSHA, you know that most the way OSHA typically enforces safety and health is through a series of standards. So whether that's hazard communication, lockout, tagout for servicing and maintenance of equipment, machine guarding, all those things that if you're operating a brewery, a distillery, or winemaking operation, you're most likely, hopefully, familiar with those requirements. But because there is no standard, specific standard dealing with workplace violence, OSHA is left to enforce it through the general duty clause, which is essentially this catch-all that requires the agency to establish, or I should say requires employers to provide employment, as you can see here, place of employment which is free from recognized hazards that cause or likely to cause death or serious physical harm. Obviously, workplace violence, particularly murder, assault, that is certainly a hazard that has the potential to cause death or serious physical harm. So then the question in workplace violence inspections and citations, the issue that tends to be the focus of defense, as well as what OSHA would have to establish to prevail, is that the hazard is recognized. So whether workplace violence is deemed to be a recognized hazard is going to really vary depending on the industry, and there are different ways that the agency can go about establishing that. So moving on then to the next page here, as you can see that there are a number of ways that OSHA may go about demonstrating hazard recognition by an employer. So there may be guidance, consensus guidance that is issued or promulgated by an industry. So certainly we see that with in healthcare fields, as I talked about earlier. Again, late night retail, car services, taxis, limousines, Uber, those types of platforms where it's a recognized hazard. But it could also be, an employer's own policy. Perhaps there's some unique aspect of their business or some other element that, because the violence can be an issue. Again, it could be based on where you're operating. It could be some unique aspect of your business that maybe other companies in that field don't have. But if it's in your policy that it suggests that you've acknowledged or recognized that this is an issue, that could be enough. It could be through if you're maintaining OSHA logs or just generally your records that show you've had a number of violent incidents. It could be through OSHA's guidance, but it could even be just through. And we don't see this often, but it could be something as simple as the case I talked about where the employee said he was threatened. So if you have an employee who's coming to you regularly and saying this employee is threatening me, I don't feel safe working with this person, he's talking about guns, he's talking about what he's going to do, if something happens, or if the next time he's asked to wear a mask or something like that. That alone could be something that's deemed to put you on notice. So there are lots of sources or ways that OSHA can go about trying to establish recognition of the hazard. So moving then on to the next slide, as I said, I've covered this mostly, but again, healthcare, social services, rehab centers, particularly halfway houses, group homes, things like that in the healthcare industry. In hospitals, it tends to be the mental health wards as well as the emergency room, because people come into the emergency room. Obviously, they've been shot, they've been stabbed, they've been attacked, and just generally tensions are running high. Family members are stressed. As far as the industry, the alcohol and whether it's brewing, distilling, winemaking, or service, to the extent that you are serving alcohol at your establishments and you're open late, I think that an argument certainly can be made that you have to be cognizant of this issue and take steps to protect your employees. Particularly, the later you go, if it's, if you're in a kind of this particular, let's say if you're operating on Bourbon Street type of thing, or in a high traffic area where there are a lot of people and going late at nights, I think certainly it's something that OSHA could and would likely try to make a case that it's a hazard that you need to take steps to address and protect your employees from. So to the extent, largely looking at the retail sector, and to the extent some of this would apply to you all, is again, you're exchanging money. So someone that third party, unknown party to you, that might come in looking to steal also product, certainly like if you have high-end alcohol that you're just brewing or distilling, money in the till, if you have a skeleton crew that's closing up late at night, so there are not many people, there's one or two people that are still working. If you have a poorly lit parking lot, or employees have to go out and do things, dumping out product or trash at the end of the evening, those are all kind of points at which there may be vulnerabilities. And so, as I said before, one of the key steps is to adopt and develop a workplace violence prevention program, and that anytime we use, as OSHA lawyers, this term program, it encompasses not just having a written procedure, which obviously is a key element, but it's conducting an assessment or an analysis of security. So looking at your workplace, where are the points where workers may be exposed to workplace violence? What's the layout of your facility? What sort of security systems do you have? What sort of measures do you have in place? We'll talk about this probably a little bit more with respect to the servers. If you have female servers in particular that are might be sexually harassed, is there some mechanism in place for them to let management know if they feel uneasy or uncomfortable about a customer? So you want to evaluate these existing measures and look into how you might be able to fill the gaps or add to those. So then the last slide on the OSHA piece, and then I'll turn it back over to Dan, just to kind of orient you to where we are in terms of federal OSHA rulemaking, just very briefly, because I don't believe that it will certainly apply to this industry. But this is an issue that's been kicking around for 4 or 5 years now. It's largely been led by the unions, and those unions that represent employees in the healthcare sector. There was, at the end of the Obama administration, it looked like we were going to get a rule, or at least the rulemaking process would begin with respect to workplace violence in healthcare. That then was tabled and kind of put on hold by the Trump administration. It's popped up again, most recently in the spring of this year, and as part of the government's regulatory agenda. It's at the very incipient point at the pre-rule stage, but again, even if such a rule is developed, it would only at this point apply to healthcare and social assistance industries. But again, that's just if a rule is developed. As far as using the general duty clause, that would still be something that would apply to your industry. So Dan, I will turn it over to you to share your knowledge about the employment law implications.
Great, thanks. So turning now to the employment law aspects of this. So in addition to the OSHA workplace violence concerns, there's also a number of employment law concerns that you need to consider and be aware of. So we're going to turn our attention to that now. And one of the most important considerations, that is really important to realize is you aren't dealing with the government, right? You're not dealing with OSHA. You're dealing with plaintiff's lawyers. And in those cases, they can be a little more creative, and it's more of a gamesmanship, so to speak, when it comes to evaluating your potential liability for things like workplace harassment or workplace violence. So let's start looking at the potential liability for you as an employer. And you have a number of different risks and potential sources of liability, and those are the ones here in bold on the screen. So first, you have the potential claims or liability to both your employees as well as third parties. So we have covered in detail over the past 20 minutes or so the potential for claims or liability for inspections under OSHA's General Duty Clause. That's what Aaron talked about, Section 5A1 of the OSHA Act. But you also have the potential for negligent hiring claims for an employee's violence or harassment of another employee or third party, a customer perhaps, that they can come in contact with while doing their job. You could also be faced with a negligent supervision claim, for instance, where there's something that arose in the workplace previously that would have put you on notice of an issue or a concern in the workplace and impose some sort of duty on you as an employer to investigate and take some corrective action. And the failure to take that action or investigate and some subsequent act of violence or harassment occurs, that could be a source of potential liability and an issue for you in litigation. Second, you have the potential liability with respect to a victim of harassment or violence in the workplace. And this can be a violation of your harassment-free workplace policy itself. In the event that an employee is injured or dealing with workplace violence and needs leave or some time off to cope with those issues that they're dealing with related to violence or harassment, if you as an employer prevent that employee from taking such leave, that could lead to a potential FMLA claim. So that's another consideration that you need to keep in mind, that we're not just talking about the harassment itself, but also the repercussions and the laws that come into play after the event has occurred, one of them being the Family Medical Leave Act and perhaps the state equivalents. Also, you need to be wary of potential retaliation or whistleblower issues, and those claims can pop up. For instance, if there's a failure to promote an employee or you diminish their responsibilities, or you don't give them some sort of raise that they would have otherwise earned, if they feel slighted following some sort of complaint of workplace violence or harassment, that could be considered a tangible employment action. Again, loss of pay, loss of their shifts, that can be the source of an employment law claim as well. Finally, you have potential liability to the individual employee accused of workplace violence or harassment. So here are some other employment laws that perhaps could come into play, and one of them is the Americans with Disabilities Act. A person that is considered the harasser or the person who is accused of workplace violence could have a mental disability, or they could even claim that they're perceived as disabled by you as the employer because of their conduct and their persistent conduct, perhaps, if it gets to that point. So you want to tread carefully with those issues, and that's why an investigation into harassment or workplace violence in the first instance is so important. You want to be forthcoming and tackle these issues head on. You also need to be mindful of some privacy issues. If an employee does have some sort of medical issue, mental disability, or something along those lines, you don't want to be disclosing that to the entire company, right? Keep this on a need-to-know basis, and any medical information that you may acquire is to be kept private and confidential. Finally, you want to make sure that the information you receive in investigating these claims is kept confidential, also to avoid defamation claims. You don't want these issues broadcasted to the entire world. Other potential employers, co-workers, again, keep this on a need-to-know basis. So now we'll go over quickly the impact of harassment claims on employers, and this is really just intended to give you an overview of where we are now in today's society. There's been a significant increase in harassment claims over the past few years in light of the Me Too movement. So it's important to understand from a legal perspective why you need to be addressing this issue in your workplace. So in fiscal year 2019, there were 12,739 charges alleging sexual harassment filed with just the EEOC. That's not including the state fair employment practice agencies that also receive and investigate these charges as well. So that 12,739 charges is probably, close to double that, or somewhere in that range. But it's quite a staggering number. In 2019 alone, the EEOC filed 144 lawsuits, 48 of which, so that's about 34%, were harassment lawsuits. And they recovered $68.2 million for victims of harassment through those litigation efforts and administrative enforcement. And that's approximately 50% more in recovery from just 10 years ago in 2010. So the focal point in the EEOC investigations oftentimes is a claim involving sexual harassment or harassment of some sort. It doesn't need to be just sexual harassment, but those are the numbers that you see on screen here. And obviously this is an issue that the EEOC is taking particular notice of, and they're paying close attention to. So if you see a charge of harassment come your way, if it comes across your desk, you need to take it very seriously. And the best way to mitigate those potential issues is to be in tune with your workplace, maintain a strong anti-harassment policy, and train your staff and management, and make sure you're holding your employees and managers accountable. And we're going to talk a little bit about, creating that workplace culture that is really the foundation of making a great workplace and a great work environment for you and all your employees. So moving on to talk just a bit more about the EEOC's enhanced focus on sexual harassment. The agency convened a task force in 2016 that issued some findings and investigations, and we're just going to go over a couple of the key ones here because it gives you a big picture of what sexual harassment is to you as an employer, but also what your employees are thinking of as they are experiencing these issues. So the EEOC found that harassment continues to be a persistent problem that goes underreported. So the statistics show that there's a small number of people that are harassed that actually come forward to HR or the employer or the EEOC for that matter to address workplace harassment. So if you're getting a formal complaint, that is likely, the tipping point for that person. A lot of times these issues are obviously not brought forward, and they're brought forward when it boils over and it becomes such a problem where it's unbearable to work in that environment. So if you do get a formal complaint of harassment, make sure you're taking it seriously and you look closely at those issues and you move pretty quick on those complaints. Of course, be diligent in your investigation, and we're going to talk about some of those techniques, but you want to make sure that you're taking this serious from the get-go. The EEOC also found ultimately that there's a compelling reason to stop and prevent harassment. Of course, the statistics show that employees enduring harassment are likely going to be less productive. There could be an increased turnover in your workforce, and there's, of course, the reputational harm for you as an employer and you as a company. And you don't want to be labeled as the bad actor amongst the public eye or your competitors, for that matter. All of this simply affects your performance and, at the end of the day, your bottom line. So a couple more key findings from the EEOC task force was how important and critical leadership and accountability are. And this is where we're going to talk a little bit more about that workplace culture that you want to foster. So where the message about what is expected in the workplace and what's prohibited, of course, harassment, violence, when that message is coming down from the top level of the company, so from the founders, the presidents, The people that are on the ground running the company as well, management, people take notice of that. Your employees take notice, and the message is clear about what is expected of them. So you want to lead by example and buy into this workplace culture from the top down. Create a culture that's respectful and make it clear that you don't tolerate harassment, workplace violence, or inappropriate behavior of any kind, and make sure managers model your behavior. Last but not least, and from our perspective, and the task force agrees with this, of course, the training must change. A lot of times when you're doing these harassment trainings, previously was the main issue was how to avoid legal liability, and it really wasn't about that workplace culture, right, and how to promote civility and respect in the workplace. So the training that you want to be providing is not, oh, the law says this, you can't do this. Your training should really be centered around creating that holistic culture of non-harassment in the workplace, and shaped more of a civility training, and obviously promoting respect and civility in the workplace. So duties to employees and third parties, and here we're going to be talking about vicarious liability, and we touched on this a little bit at the beginning a couple slides ago, but looking at the liability that you may owe to your employees, you don't have a responsibility to control someone else's conduct absent some sort of special relationship. So an employer has the duty to control the actions of its employees when actions are within the scope of their employment, and this is a legal term. So when you have someone that's performing a task in the course of their duty, they're doing something for you as the employer, that's where liability can attach. So we see this in situations a lot where folks have interactions with the general public, right? So as breweries, wineries, and distilleries, you need to be on the lookout for this. If you have an employee that is not harassing, per se, an employee, or even a member of the public, but is a little too forward with the customer or the employee, and you do receive a complaint that an employee or a customer feels uncomfortable, take note and make sure that you're taking action quickly to put that to bed and get it out of your workplace, and make sure that you're reinforcing that workplace culture that you want. And now we'll talk quick about the negligent hiring piece. We also mentioned this earlier, and the potential for a negligent hiring claim. This can come up in the context of not conducting background checks oftentimes, and employees that could have red flags from the start. So obviously one thing to consider in administering background checks is state law, and this is of course state specific. It's different in various jurisdictions, and it could even come down to local laws. For example, if you're in Maryland, if you're in Montgomery County or Prince George's County, there are certain restrictions on background checks that you would otherwise not be subject to, but for your company being in those two jurisdictions. But if you are conducting background checks, this is really a fact-specific inquiry. You don't want to completely shut someone out of your employee just because there's a mark on their background check. But you want to look at it closely, right? Make sure that you give someone the opportunity to explain a red flag that may be on their background check, evaluate whether that conviction is job related. You want to evaluate how long ago it took place. Ultimately, you want to take a reasonable approach in evaluating these employees, or these applicants, I should say. The more serious the crime and the more directly related to the job, the more careful you want to be in handling that applicant. For instance, if an applicant was convicted of sexual assault on a customer 4 years ago, or some recent time while working at a restaurant, that's obviously a very important consideration for the folks on this webinar. Make sure you're going through the facts on a case-by-case analysis. Negligent supervision or retention, and this is the corollary to negligent hiring claims. So this is something you learn while the employee is working for you, and it suggests, their behavior suggests that they pose some type of risk to coworkers or your customers. So courts typically use an ordinary care standard. In other words, a generally prudent employer would know that this employee posed a hazard and they should have done something as a result. So if you have multiple complaints coming from employees, for example, if we have multiple complaints from female employees about one particular male employee, or it even could be a number of male employees, that signals there could be a problem with your workplace culture. But if there's a number of different complaints from female employees about a male employee making suggestive comments or overt acts, for example, touching them, and you do nothing about it, if something worse happens at the workplace, for instance, is sexual assault, you could be subject to a negligent supervision or retention claim. Next, we're going to go on to background checks. A best practice would be to engage and use background checks as part of your hiring process, and we touched on this just a few slides ago. But there's a few laws to consider in performing background checks that we want to make sure that you're aware of. If you do choose to do background checks on your employees and your applicants, most notably, the key and I guess the marquee background check law, for the federal law that is the Fair Credit Reporting Act. There's a number of different procedural requirements that employers need to strictly follow, such as disclosure and authorization forms, as well as pre-adverse and adverse action notices. The corollary to that is, of course, the state laws that come into play, and even local laws. As I just mentioned, Montgomery County, Prince George's County have local specific background check laws, and they often offer additional protections to applicants when a background check is performed. So you want to make sure that whatever vendor you're using is checking all the right boxes, and there's a pretty streamlined way that you can go about doing that. So let's just take Maryland, for example. Maryland law prohibits employers from asking applicants about criminal charges that have been expunged. In addition to that, Maryland's Office of Fair Employment Practices has issued guidance for employers which cautions them not to ask about an applicant's arrest record or general conviction record. The guidance also indicates that employers should ask only about convictions that bear a direct relationship to the job and have not been expunged or sealed. So the other notable background check issue that you should be aware of and keep an eye on is the trending ban the box laws, as those prohibit employers from asking employees about criminal convictions on the employment application itself. Maryland and DC both have ban the box laws. Virginia has a quasi ban the box law that prohibits employers from asking applicants to disclose any information or criminal convictions related to the possession of marijuana, but everything else is pretty much fair game. So Virginia is a little bit different, but most employers generally end up having these discussions at the interview stage or post a conditional offer of employment. So now we're going to move into strategies for your workplace, and we're going to get into the tips. We've gone over the legal considerations in the remaining portion of this program the last 15 minutes or so. We're going to discuss some of the substantive strategies that you can take to protect your workplace. And the first one is to maintain a clear anti-harassment policy. If you put something in writing and train employees on it, this really shows a commitment, a real commitment to addressing the issue, and it ultimately helps prevent harassment in the workplace. You're setting that standard in writing and distributing that to your employees. Make sure that it's written down, distributed, of course. Most of the time it can be distributed in an employee handbook, but it's also useful sometimes to issue it as a standalone policy and highlight it specifically to employees on a routine basis. Of course, if you're doing that, providing that training specifically on workplace violence, harassment, sexual harassment, in conjunction with the written policy is, of course, the best practice. But the policy will best serve its purpose when it's clear to understand. Again, the policy and the training, it shouldn't get into the legalese of here's what the law says, right? But rather set those expectations and start building that culture that does not tolerate harassment. You want to clarify what harassment is, how it should be reported, outline the investigation process and what are the potential consequences for violating it, right? The discipline. And that can be up to and including termination, of course. It's an important topic, that an important piece to this entire policy is that employees understand the repercussions. We do caution against a zero tolerance policy per se, the discipline, and that's not to say that harassment is okay, but we want to make sure that the discipline is appropriate and proportionate to the offense. So there may be instances where termination is not appropriate, and some other form of discipline will suffice, right? A write-up, verbal counseling, and retraining on the company expectations and the harassment policy, anti-discrimination policy, that may be appropriate. And one other note here, the policy should include a clear protection from retaliation for both reporting and for participating in an investigation related to workplace harassment or violence. Many people are afraid to come forward, and that was found in the EEOC investigative report that we talked about. So make sure that employees feel safe coming to management about these issues, and make sure that in those reporting procedures that you have, that there's multiple avenues for employees to report these workplace instances of harassment. So moving on now to one other thing that you really need to keep in mind about harassment, right? This is not something that is just limited to your workplace, and it's not limited to work hours. Harassment claims can rise from a ton of different situations that occur outside of the workplace, like a late night happy hour happening informally at a bar, company parties, stuff that you see on the screen here. It could be a social event. It could also surface completely outside of the realm of work. You know, this can happen between coworkers in text messages, unwanted calls, harassment on social media, and stalking, right? So this can be something that surfaces in the workplace, but it can be something that surfaces outside of the workplace. But obviously the common denominator is the workplace itself. And if an employee feels uncomfortable because of something that happened outside of the workplace, you still want to address it. So when can a company be liable for harassment? A company can't control everything, right? You're a brewery, a winery, or a distillery. You're running a business and you have a lot of people coming in and out on a daily basis. You can't control everything or everyone in your workforce 24/7, right? So when exactly can you as a company be liable for harassment? Now we're getting into the civil rights component of the law. A company will be held liable for harassment under Title VII of the state equivalent law for the actions of a supervisor or other management representative. It doesn't result in some sort of tangible adverse employment action, right? Like a termination. The employer can assert an affirmative defense if it exercised reasonable care to prevent and promptly address and correct the harassment. So in other words, make sure that you have a policy against harassment and you have those multiple avenues for reporting. The employee that is the subject of the harassment needs to exercise their rights under those reporting procedures in order to further their harassment claims. So if you are providing that policy, you have multiple avenues for reporting, and an employee is not taking advantage of those, that is an affirmative defense in the event that you do face yourself with a harassment lawsuit. And the second component of that is that the employee unreasonably failed to take advantage of those procedures or the corrective opportunities provided by an employer. So what you need is an opportunity to address the harassment in the workplace. What about coworkers or vendors? Employers can also be liable for harassment by non-supervisors and third parties as well, but the standard, of course, is slightly different. That is, if management knew or should have known about the harassment and failed to do anything about it. So you can't keep secrets. In other words, employers can't keep these issues swept under the rug. You need to investigate promptly, and this is where the message to management is so important. A lot of times management might think, oh, I can handle this on my own. This is just not something that is, in my opinion, rising to the level of harassment. That's what you don't want. You don't want managers going rogue, keeping this from HR, keeping this from, you know, company superiors, and simply saying, oh, this is a problem that I can handle, because oftentimes it might get swept under the rug. You know, if business is good and an employee comes and complains about one single employee just to a manager, and the manager thinks, oh, you know what, this is just worthy of a conversation, and again, nothing changes, that's a red flag, and you know, you could be on the hook if this continues and it becomes an unbearable situation for that employee that is subject to the harassment. So make sure that you're investigating promptly and you're remedying the issues promptly as well. So when we're talking about the different elements of your policy, the one thing that it's a very important piece, right, and important for you to have is a clear complaint procedure. And I mentioned this just a few slides ago, that you want to have multiple different avenues and ways that employees can do this. But really, the complaint procedure wants to cover the 5 bullets that you see on the screen here. Who should report, who to report to, how to report, when to report, and what managers should do. So an employee who is harassed and or an employee who witnesses harassment, those are the employees that should be reporting. Make sure that you have multiple avenues that employees can report these complaints to: managers, human resources, top executives. A lot of employers even have an anonymous hotline or some other way that employees can anonymously report these issues. When to report, obviously that's immediately. You want to be able to get witness statements and address these issues while it's fresh on people's minds. And then what managers should do, of course, that's they need to take immediate action to address harassment if they receive a complaint. Bystander intervention, we briefly touched on this concept of bystander liability, and this is where you can have an instance of harassment based on a witness observing inappropriate behavior. Like we said, you know, throughout this presentation, most coworkers are not comfortable when harassment occurs around them, even when they're not the direct victim, right? It goes underreported. So if someone sees something, they should feel empowered to report and know what resources they have at their disposal to make that report. Again, employees should be held accountable and make sure that they're reinforcing and upholding your culture, your workplace culture. So give them the resources to support their intervention and create that sense of responsibility for them to do something and not simply stand by. Next, we got a couple more slides here before we wrap it up, and we'll try and get through these fairly quickly so we end on the hour. But the next step is conducting, after you receive the complaint, what do? You need to conduct a prompt investigation. And here we'll cover a bit more of how you should do that following that report. So you need to establish a procedure to investigate all the complaints that you receive, right? And especially complaints of harassment. They should be prompt, objective, and include interviews of the complaining employee, the alleged harasser, and any witnesses that are identified. Of course, it should be kept confidential to the extent practical and as permitted, while recognizing that you can't maintain complete confidentiality 100% of the time, right? Because you do have to interview employees and see what's going on in your workplace. But that information, whatever you obtain, it should be kept confidential and it shouldn't be broadcasted to the public or other coworkers. The employer representative, whoever is doing that investigation, make sure that they're creating contemporaneous documentation of the investigation and that is recorded, maintained as a record. And finally, depending on the outcome of the investigation, the employer may need to implement discipline, of course. And there can be a range of discipline depending on the actions, but the key here is that it should be proportionate to the findings. And I'll go over the last slide here before I turn it over to Aaron. responding to conduct, and this goes to that range of behavior and the proportionate discipline that you want to dole out. So as you can see on the screen here, red, yellow, green. Not that green is good, but if you have an investigation that determines an employee's conduct was illegal harassment, the response is discipline and perhaps likely termination. The other end of the spectrum is that no harassment occurred at all, and there may have just been a disagreement with between employees. So there, you might want to follow up with the accuser and the accused, explain the outcome, ensure that there's no retaliation against either employee or any witness that participated in the investigation. And then there could be something in the middle, right? It could be inappropriate or uncivil behavior. And here, the response, it could depend on the conduct, right? And here's perhaps a situation where a written warning, a verbal warning, and some retraining on these policies in your workplace culture is appropriate. With that said, I'll turn it back over to Aaron to wrap up the last couple slides here and send you on your way.
Thanks, Dan, and I will try to power through so we keep as close to schedule as possible. Just a number of other best practices and essential elements of an effective program that is addressing both workplace violence as well and harassment is to provide employees, so non-supervisory, non-managerial, generally hourly employee training. Every employee should be trained on these very important topics. And as Dan said, for many years, the training focused too much on, I think, the legal aspects to it. And it could be pretty boring. I think we've all been in training programs where the people are rolling their eyes and like, oh, here we go again. It's a dull speaker. It's a dull topic. So you want to make sure you make it interactive, provide real world examples. It should be customized or catered to your industry. So what are the issues that happen back of house, that happen if you do have customers, if you're serving your products, in a restaurant or tap room setting? What are the issues that they might encounter? How do they deal with difficult customers? Go through the policy, certainly emphasize and go through the complaint mechanism, what they should, who do they go to? What are the different means that they can use to raise a complaint? Whether it's online or telephone or in person. What happens when they raise a complaint? What can they expect so it's not this kind of great unknown? And go through the examples of what's acceptable, what's not acceptable, why it's not acceptable, types of behavior, types of conduct. That's really what you want to provide when you're training your non-managers. So then looking at the next slide, as far as obviously equal, if not more important, train your managers. It's very different. And I always recommend either that if you may choose to do kind of the basic training for everybody and then have a separate session for your managers, or just do manager training entirely separately. But the managers need to understand their role. There's a more legal component that's included. There may be aspects of personal responsibility or personal liability that can attach to managers who either fail to act or more likely who may engage in inappropriate or illegal conduct themselves. Certainly here in Illinois, there's the potential for personal liability. So one of the things I always include in training out here is that you as a manager might be sued individually. You might be forced to pay for your own lawyer to defend yourself, and I can give examples of real world examples where that's happened, and what sort of costs people can have to bear, which gets people's attention. They need to understand, and Dan alluded to this also, what they should do as a manager, as an agent of the company, if a complaint is brought to them, why they have to act in every instance, why they can't promise confidentiality to somebody, why they can't just say, oh, I won't bring it forward to senior management or HR. And again, walking them through the examples as well. So not only of what they can or cannot do, what they shouldn't do behavior-wise, but what do they do when someone comes to them? Almost every time I give a training program, and we go through that example of, well, what do you do if someone says, hey, I have a personal problem and I would like to talk to you about it. Can you keep it between you and me? Sure. Yeah, I'm happy to do that. And then you find out it's a harassment issue. And then you have to explain to them, no, now that I understand what your issue is, I can't keep it between us. Walking them through that. Almost every time that I go through that, one manager raises his or her hand and says, oh, I've had a situation like that. What should I do? And then we end up having to conduct an inspection or investigation. And even talking to them about what to do if they see something they're not sure. I really look at this type of training as the primary objective is to teach your managers how to spot the issue, how to spot things that might be a problem, and tell them what to do about it. Not that they need to be legal experts, not that they need to define sexual harassment or workplace violence or what have you. Just being your eyes and ears out there, elevating the issue to the appropriate person. Some other best practices, and I think Dan said this also at the beginning. Make sure that the policies, the training, it's all supported from the very top. It always helps if you're doing training that either there's a recorded introduction from owner or senior management. Ideally, they're present for the training if it's an all-employee training, or they introduce the speaker and really give even just a brief talk about how this is a core value for the organization and that they expect everybody to comply. Once you adopt and implement a policy or a procedure, make sure you review it from time to time. This area of the law can change quickly. Certainly during the Me Too movement, there have been lots of updates and changes. So you always want to make sure you've got the most current and well-drafted policy. Talked about the training. If you really want to kind of take your compliance efforts to the next level, think about addressing issues like unconscious bias, cultural sensitivity training, because in many cases, as Dan said, there may be a misunderstanding. It may have just been kind of a smaller issue that had nothing to do with race or gender or what have you, and then suddenly those issues get pulled into it, and suddenly what was not illegal may now become illegal. So if you have the ability or the tools to do that, I think that can be great as well. And making sure that employees understand. We talked about bystanders, we talked about managers and their roles, but that every employee has an obligation or a role to play in this process, and that everyone can, if they don't feel comfortable standing up and addressing it head on, so everyone knows, even if they're not the target or the victim, that there are ways that they can report issues or concerns. It really can be a total team effort when you're dealing with workplace violence and harassment issues. You look at all the different topics here, the bullet points, from having your security or facility personnel involved, to whether it's HR or legal. If there's an incident, you might need media relations. You certainly might need to deploy or retain an EAP provider to counsel your employees in the event of an incident. We've got training from safe work practices to identifying risk factors to reporting procedures. But also, certainly in this pandemic, one of the things that many of our clients are doing is providing managers with de-escalation training, meaning helping them, giving them some tools to deal with the difficult customer, the difficult third party that has come onto your premises and wants to wear, is refusing to wear a mask. How do you redirect that person? How do you deal with that issue? Making sure that you have identified, talking about masks, of how are we going to deal with this issue? Who do we expect to enforce the mask mandate? Are we going to leave it to the host or hostess who's maybe a college student, or even a high school? Well, it wouldn't be high school if you're serving alcohol. A college student or someone who's new to the job world. Are we going to limit it to managers, which is what many of our retail clients do? And then obviously it ties into workers' compensation and making sure you have the right liability insurance coverage in the event of an incident. Maybe it's so serious like the Twin Peaks incident that you've got business interruption. And then whether you need surveillance, whether you're conducting background checks, if you hopefully have some sort of relationship or ties to local law enforcement, so for example, if you know that you're going to be going through a difficult, potentially contentious termination, many clients will conduct or notify local law enforcement of what their plan is. In some cases, they may have someone stationed nearby, or they'll be driving in the area at the time. I've even had clients that have conducted threat assessments before taking action, or hired even private security to be in the next room. All manner of things when you're dealing with difficult issues like this. And then last but not least, just to, I think, kind of move on to the next slide, just to cover a few kind of final points. So just to tie it all together, as I recommended earlier, really focus on developing an overall workplace violence prevention program. We talked about zero tolerance, and as Dan said, it's a loaded term. And so when we talk about, being careful about using that term, it's that ultimately we don't tolerate it, but how you respond to what you don't tolerate is going to vary depending on the type of incident, the type of severity. So I really think that's the message that you want to get to people. Making sure that you've got different types of controls in place. So it may be, for people that are dealing with money, there may be even a safe room or some locked area that they can go in the event of an incident. Having administrative controls, so it could be if someone's making a cash drop, they always go with another person. So that's a policy or procedure that you would draft. Make sure you track, and if you have to report these potentially, if an employee is injured. And as just to say, I think one more time, again, the importance of training for employees to understand the elements of the program, to understand how to respond to aggressive behavior, whether it's from in healthcare, a patient or a customer or a vendor, or whomever. To the extent that you might be getting into, you have concerns that an employee may have a mental disorder or something along those lines, you could basically cover this an entire other program, but then you're talking about the Americans with Disabilities Act. So you have to be careful what you say to a person and about a person. If you suspect that there may be mental illness, you really want to just focus on whether they can do the job, whether they can handle the stresses, and wait for them to disclose or express some concerns about their mental health. There may be ways that you can send them for an exam or a test, and we're happy to talk about that offline. Ultimately, many of these things are just going to be handled through your performance management process, and let people who are acting in a way that may not be so serious that it's a terminable offense, but still needs to be addressed and documented through evaluations and through counseling. So I think that is it. So we would encourage you all, if you have time or interest, to check out both our OSHA blog, which is found at OSHADefenseReport.com, and our labor and employment blog at the EmployerDefenseReport.com. We also do webinars every month. So if you go to our website, conmacl.com, you can check out and sign up for both our employment webinars as well as our OSHA webinars. So that's it for our program. We hope you found it helpful and got some good tips and suggestions. And if you have any questions or comments or feedback about future programs, or you want to talk about workplace violence or harassment, please don't hesitate to give Dan a call or to reach out to me if you'd like. Thank you, and have a good and safe day.
Thanks, everyone. Bye-bye.